Thank you for that. I'm here today to give you an update or a masterclass in employment law. And what I thought was the best thing to do was to run through some recent case law that I think is of interest and picks out quite a wide range of employment law topics that hopefully you'll be able to learn something from and take something away from what I'm talking about today. What I thought was it's likely the audience here that you're going to be from quite a broad range of healthcare providers, NHS, social care. I mean, what in the audience today, so just to give me an indication, is there anybody here from the NHS? Okay. And providers? Okay, so that's more. That's probably accounts for most of you here today. So what I plan to do is to go through some cases. I've picked up a case on disability discrimination, a case on whistleblowing. I've got a disciplinary proceeding and also a case in relation to contract of employment. So I want to try and make this a little bit interactive today so you can all think about things a little bit. And the first case that I picked up on involves, as I say, disability discrimination, and it actually involved an obese claimant. And the question here was whether obesity constitutes a disability for the purposes of the Equality Act. So what do people think? Would you think that obesity would constitute a disability? Who thinks yes? Okay, and who thinks no? So there's more dissenters here today. I'll just take you through the findings. I would say the answer is yes, and I will explain why I think it's yes. Basically, in this case, Mr. Walker was an obese, was an individual who suffered from obesity. He had something called functional overlay, which basically means an excessive, or from reading the case I've learnt, means an excessive reaction to symptoms. And it was felt that it was actually compounded by the fact that he suffered from obesity. Now, because of this, he then had an awful lot of other conditions which resulted from this functional overlay, such as knee complaints, and he had arthritis and anxiety and depression. So there was a whole host of different conditions, but they all related to the cause, which was the functional overlay. And there actually was an occupational health report which said that they couldn't find a cause. There wasn't a set cause for this, for all these conditions. And in fact, the occupational health advisor felt it was because of behavioural and mental issues that these things had come about. They couldn't find the cause, anything that they could evidence and say this is what's caused it. So the Employment Tribunal found, I think quite surprisingly, that this claimant wasn't disabled. It then went to the appeal court, so it went to the Employment Appeal Tribunal, who looked at it again, and they looked at it a little bit more in the round, and they basically decided that what you look at is the effect on the employee. So when you're looking at whether somebody's disabled, you look at the effect as opposed to the cause. Now, just to update everyone, the definition of whether somebody suffers from a disability is it has to be you have to have a mental or physical impairment which is substantial, and the test of whether something's substantial is quite a low test. It's basically just more than trivial. It has to have a long-term effect, which it's been found it has to last for more than a year, and it has to affect your day-to-day activities, such as things you do every day, walking, eating, sleeping. Now, all of those things did come into play, but what they actually looked at was whether it was a mental or physical impairment, and the Employment Tribunal in this case decided it wasn't an impairment, but that was then overturned, and it was decided that actually that was an impairment. So the things that we can take away from this case is basically what is meant by an impairment. You give the word its natural meaning, so you look at the effect on the employee as opposed to whether there's any cause behind how they come to be suffering from that condition. And the Employment Appeal Tribunal decided that it wasn't the obesity itself that was the disability in question here, as I think, so you probably, the people who said no, you are right. But if you look at it in the round, the effect that causes on the person does constitute a disability. And I certainly think some of the conditions that this man suffered from, and if you look at how they affected his day-to-day activities, etc., there was a substantial effect on him. So I think it was right that he was considered to be disabled. I also think that we may have a situation now where if people are obese, that it's maybe more likely that an employment tribunal would find that they do have a disability because they're more likely to have all the conditions that stem from from obesity. Does anybody have any questions on that one? Okay. The next one I wanted to pick up on, just so I can pick a couple of different areas up for you all to think about, is a case involving whistleblowing. This has just been reported. As I'm sure some of you will know, whistleblowing, or all of you will know, whistleblowing is where it's what's called, if somebody raises a protected disclosure. So if an employee raises a disclosure in their employment and says that some kind of malpractice has occurred, they then have the right not to be subjected to a detriment or be dismissed because they've raised that complaint. And it's always been the case that right has existed, or it's existed for a number of years now, during employment. And the question has arisen recently as to whether you can blow the whistle and raise a complaint after your employment has ended. So what do people think? Do you think you can blow the whistle and raise a protected disclosure after your employment has ended? Who thinks you can? Yes. Okay. And who thinks no, you can't? Okay, so we've got more people thinking yes, you can do this after employment has ended. And the answer is yes, you can. And in this case, what happened, it actually involved a firm of solicitors, and an individual raised a complaint to the Solicitors Complaints Authority after his employment had ended. That was then looked at, so that was found to be the protected disclosure in this case. That was then looked at, and the employer in question then thought that actually the employee had been dishonest and had actually forged some documents. So they then raised this as an issue to the professional body that regulates solicitors. So that was found to be a detriment that had occurred, and all of this occurred after the employee's employment ended. And previously it had been found to be the case that you can have a detriment occurring after the end of employment. So for example, if you were to issue a reference and you gave somebody a negative reference because you knew that they'd raised a complaint just before their employment ended, then that could be found to be a detriment. But in this case, it was looked at what happened after employment had ended, and it was found that you can have a protected disclosure that's made after employment's ended, and a detriment that occurs after that time as well. So the thing to take away from this one is that, like with the discrimination laws, with whistleblowing, that you can blow the whistle after employment has ended. So I think you do need to look out for individuals raising complaints or raising issues with you, perhaps in writing, after employment has ended, and considering whether that could constitute a protected disclosure. There's actually no time limit on when that would have to occur, so it could occur at any time. And I think, bear in mind, think about what happens after employment has ended. For example, something like giving references and making sure that you're not giving unfavourable references unless there's good reason to be doing that. The next case that I wanted to look at, to go for a different area, relates to termination of employment and contracts of employment. Now, I'm not going to ask you a yes or no question on this one, because I think you need some more facts for this one, so I'll just have a look at this. This is a case that has been quite, I don't know if anybody's heard of this case of geese or gays. No. This is a case that I think has had quite a wide implications. It will affect the health sector as well as all employers. And although it actually related to a banker, I think we still can draw analogies with other employers. What happened, and it all relates to payments in lieu of notice. And what happened in this case is the banker concerned was given notice with immediate effect on the 27th of November. So he was given notice, he was told to clear his desk, and he was then given a letter saying your employment's ending with immediate effect, and he was escorted from the premises, so he was asked to leave the building. And the bank tried to argue that was the date that his employment ended, the date that they felt that it ended with immediate effect. He was subject to a 3-month notice period, and in his contract, or it was actually in the handbook, it said that he had a payment in lieu of notice clause. So that's basically a clause that authorises employers to be able to pay in lieu of notice. And they exercised that clause, and they did pay in lieu of notice the 3 months' money, and they paid the money on the 18th of December. And that was a sum of £32,000. But they didn't confirm what that was for, so they just paid him the money and didn't explain what that was for. And that date is a relevant date because the actual payment in lieu of notice clause said that employment will end with immediate effect when the individual gets the payment. And then the next particularly relevant date was the 4th of January and the 6th of January 2008, when the bank actually got their act together and wrote to the individual and said, your employment has ended and we've paid you this payment in lieu of notice of 3 months' money. So they actually confirmed that had happened, and he received that on the 6th of January. Now, the question that arose in this case is, what was the date that employment actually ended? Was it the 27th of November, 18th of December, or 6th of January? And that was, and this case will have quite wide-ranging implications in terms of what the relevant date is. So what do people think from what I've told you? Do you think it was the first date when he was told you're going and we're issuing with notice, your employment's ending with immediate effect? Who thinks it was that date? Anybody want to? I can hear some deliberations at the front. What do you think? Yeah. 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 You can pay, I mean, it's, yeah, you can pay in lieu of notice, and it's always been thought that it should end on that date. And there's two theories. There's the automatic theory in terms of it should automatically end on that date, and which would provide certainty and would be practically sensible. Or alternatively, there's contractual principles which basically say the employee could elect for it to end at a later date, which I'll come on to. So who thinks it was the 18th of December when he got the money and he was told that when he got the money, his employment would end? Yeah, a couple of people. And what about the last date, when he actually received confirmation that he'd had the money? Who thinks that date? Okay, majority of people think that date. You're all right. I do find... basically, employment did end on the 6th of January in this case. Now, this is a case where the employee concerned was found he did have an effective payment in lieu of notice clause. Are you familiar with payment in lieu of notice clauses? Yeah. So this employee did have such a clause, so you would look at the wording of that. And the fact that the bank didn't get their act together when they should have done meant that it didn't become effective until they properly operated the clause. So if they had at the outset said, you're going, we're paying you in lieu of notice, here's the money, and this is what it relates to, it would have ended then. But because they didn't do that, it ended at the later date. Now, I don't think that is that surprising, but the other thing they've decided, which actually I think is quite important, is where you don't have a pile-on clause or a payment in lieu of notice clause in the contract. And a lot of employers don't have such a clause in their contract. And if that's the case, then basically, if you pay in lieu but you haven't got a clause that authorises you to do that, you're breaching the contract. And that's what's called, it's a serious breach of the contract. It's called repudiatory breach in legal language. And the contract law has said, if you have this serious breach of contract, then the employee should have to accept whether to accept the serious breach or not. And what they've said in this case is that it is up to when the employee accepts that breach. So say you don't have a payment in lieu of notice clause in your contract, and I know quite a lot, for example, NHS contracts, some may not have payment in lieu of notice clauses in them. Potentially I've seen them for more senior employees, but not necessarily for all employees. If that's the case, then employment could end at a later date when the employee elects. If you were to say your employment's ending, you're leaving now, and we're paying you in lieu, so it wouldn't necessarily end on the date that they go. Now, it was relevant in this case because it involved a banker who was receiving a massive bonus payment, and if he had the 3-month notice period, which would send him into the next bonus year, he would get several £1 million more bonus than if he was getting the bonus the previous year. So obviously that's not as relevant to us. It's unlikely we're talking about employees who are getting millions of pounds worth of bonus, but there are other situations in which it could become relevant in terms of when an employee's employment ends. So I think this really is one to watch. And I think it's key to look at a learning point from this is to look at any pile-on clauses or payment in lieu of notice clauses you do have in your contracts, and to check that you're happy with the wording. And also, it's key to be able to communicate the decision. So if somebody is going, it's key to say you're going at this point, and using clear and unambiguous language to say this is why you're going. Now, And the other thing to note is where you don't have a payment in lieu of notice clause, there may be other considerations to take into account. So that one is quite an important case, I think, and I certainly have been advising on that quite a lot, and it seems to be coming up quite a lot. And the final case that I wanted to look at involves the right to a fair trial in disciplinary proceedings. Now, the reason I brought this one, I'm dealing with this one, is this case involved an NHS consultant, and it's talking about the right to a fair hearing, which stems from the European Convention of Human Rights, so the European Convention sets out civil rights that apply to citizens, such as the right to have a fair hearing. And the European Convention of Human Rights is put into UK law in the Human Rights Act, and public sector employers have to act in a way that's compatible with the Human Rights Act and with convention rights. Now, if you're not a public sector employer, it still could become relevant because employment tribunals are public bodies who have to make sure they're doing things that are compatible with the European Convention of Human Rights. So if an individual were to bring a claim to an employment tribunal, then the employment tribunal would have to construe the claim in a way that's compatible with the convention. So in this case, there were some disciplinary proceedings, and the question was, do Article 6, right to a fair hearing rights, come into play during that disciplinary process? So can the individual concerned argue that they haven't had the right to a fair hearing and that their European Convention of Human Rights rights have been breached? What do you think? Do you think they can argue that? Yes? Yeah? A lot of nodding. Does anybody think you can't argue that? Okay, not as many. In this case, the answer was no, you couldn't argue that. And I think that is becoming more common. This is something, I don't know if anybody has dealt with anything in this area in the NHS, but it has been quite topical. But this case involved a consultant who seemed quite a problematic consultant in terms of that he was subject to a disciplinary, which was going on for, I think, he was suspended and off work, I think, for about 5 years while it was being looked at. He then went off on long-term sick leave, so it was reclassified and re-looked at, and it ended up that they had to try and get him back. They decided to put him back into work, and he had to be retrained. So they looked at reskilling him and looked to put an action plan in place, but he wouldn't agree to the action plan. So, and he was quite obstructive, and he was very difficult to manage. So in the end, he was dismissed because he was such a difficult employee and difficult to manage and not cooperative. So he was dismissed for that reason, and he then said that he should have an independent and impartial panel, and he talked about his rights to legal representation. So he said that the panel that dismissed him should have been constituted in a different way, and that because it wasn't constituted in that way, it breached his right to a fair trial under the European Convention. Now, this went all the way up to the Court of Appeal, who decided that because this wasn't an issue that affected to his civil rights in terms of his future profession, it just related to his contractual right, i.e. the disciplinary proceedings, and if he was dismissed from that employment, then that wasn't something where the European Convention was engaged. So it was found that it's only in a situation where you may lose your entire profession, i.e. that you'd have no chance of working as a consultant again, that would be a problem. Now, it was found that just because you've got this blot against your name and it would be very difficult for you to work in the NHS again, that's not enough for it to be a breach of the right to a fair trial. Now, I think the thing to take away from this is that basically it would have to be something you'd have to be affecting somebody's entire profession, so the right to practice a profession going forwards before this right would potentially be engaged. And the debate now seems to be moving towards, even then, it's unlikely that you would have that right, because the way that they looked at this is to say that actually you would still have the right to then to have your case looked at by the GMC, and it would be then that should be looked at in terms of your civil rights, which shouldn't be at the time of the internal proceedings. And it has been looked at in a case involving a teacher in a school, where it said it is possible if you can show that it would substantially affect the hearing where your civil rights would be looked at, i.e. the the GMC hearing, if it would affect that substantially, then potentially you could look to say it's a breach of your right to a fair trial, but that would be difficult, and they've found that basically the GMC are independent enough that they're not going to change their mind just because of what the internal proceedings have found. So I think even though this is something that has been looked at, it's not something at the moment that is coming into play as much as what the debate had previously been, that it was coming into play. I think, as I've said, this will affect private sector employers as well as public sector, and there is still a potential that a consultant, for example, who may lose their livelihood, should have the right to, for example, legal representation and the right to a fair trial. But I think in general, in situations of gross misconduct, you're not going to have this right to a fair trial coming into play. Has anybody got any questions? Yeah.
Hello. Thank you for the last explanation around the right to a fair trial. That was very helpful. We advise and support a lot of nurses in their employment context, and it's certainly something we are very, very conscious of with regards to nurses. You mentioned doctors, but actually nurses are covered by the Nursing Midwifery Council. Yeah. And we found over and over again that any proceedings locally tend to be transferred over to the Nursing Midwifery Council proceedings, and therefore does have quite a substantial impact on any proceedings there, and their right then to be able to work as a nurse, or ability to work as a nurse professionally. So we are very, very cautious in view of those cases, and having been involved in the Crawford Suffolk mental health case recently, quite anxious and to advise employers that they should go through very, very rigorous, proper disciplinary processes if they're dealing with professionals.
I think that's absolutely right. So obviously you still have the full process, and it's not saying you shouldn't have the full process there. I think the main argument seems to have been around the right to legal representation, because to have a lawyer representing you, and then that means that the employer then wants a lawyer representing them, and it just makes the whole process adversarial, and it just doesn't need to be. So it's just it's not, you obviously have to follow your fair process and follow your contractual rights and what you've got down in your policies, but it's just a question of whether this right to a fair trial is engaged, and I think it's less so than it previously had been. I don't know if you're aware of that case of Kilcarney, where in that doctor case it seemed to be swinging the other way. Thank you. Well, I think I've used up my time, so I will be around for a little while longer. So if anybody's got any other questions, please just let me know. Thank you for listening.